The title of my book is Legal Pluralism in Central Asia, Local Jurisdiction and Customary Practices. The foundation for this ethnography is my doctoral dissertation, completed in spring 2016 at the Humboldt University Berlin. This book is a report on historical, anthropological, and legal research which examines legal customary practices in Central Asia, especially in Kyrgyzstan. My interest in conceptualizing a research project within legal anthropology grew from participant observations of several conflict situations that evolved as a part of severe traffic accidents. The subsequent regulation of these incidents offered me an interesting constellation of formal, informal, and traditional approaches, as well as different sources of law existing side by side. I have been studying this topic for more than 10 years now, collecting and reconstructing more than 50 cases and incidents. Some of them I have analyzed and presented in full detail in order to provide an adequate examination of the law and local justice. My guiding questions included: what are people in Kyrgyzstan doing when they have grievances? Which mechanisms, strategies, and what kind of laws, concepts, and institutions do they prefer and apply to certain situations of conflict? Who are the social agencies with necessary authority and law and decision-making capacities? How do individuals and communities generate order and maintain social equilibrium, serve or make justice, or more precisely, how they ensure its actualization and attainment? The core of the book is a description of cases which deal with severe accidents, crimes, violences, and disputes. Most of them, especially those causing serious physical damage and human loss, include potential risk of heavy conflicts and bloody clashes. The most interesting fact in this context is that the incident of negligent homicide, once an ultimately state-regulated subject, has become an issue between two families, kinship groups, and communities. They are settled in a private circle in which individuals seek redress deemed appropriate and acceptable within a socio-economic context. Furthermore, actors are motivated by their individual agendas, interests, and beliefs, as well as their own perception and interpretation of law and justice. The book reveals the dynamic, changing, and living character of law in specific context. It is expressed through ritually structured communicative exchange such as apology and forgiveness, through processes such as negotiating, disputing, and working out compromises, as well as through dictums and proverbs with binding characters. Thus, the reader is enabled to see the local perception of law and justice founded in people's assumptions and beliefs, in codes of shame and honor, in local mores and ethics, as well as in religious terms. In sum, the book makes a powerful case for the importance of shared traditional values and virtues of people struggling to solve problems and conflicts. I would recommend this book to anyone who has an interest in legal anthropology, customary practices, and conflict management issues, not only in Central Asia, but also across the world.